first, as a preliminary matter, I know that this is somewhat unorthodox that an individual would seek a summary disposition in a criminal case utilizing MCR 2.116C8, but we believe that the law and the facts make that permissible in this case. The reason being because, first, the civil procedure rules do apply in criminal cases, as is articulated in MCR 6.001D. When it comes to the people, they have said in their response that this is something that is exclusively within the purview of the civil rules of procedure and only civil cases. However, we maintain that is not the case. As you have seen in our filings in our brief, People v. Grove, also People v. Schultz, shows how particular matters of civil rules of procedure are applicable in criminal cases. And furthermore, if I take a look at 2.116, it doesn't say that that particular rule regarding summary disposition is only used in civil contexts. And there's really no analogy or anything similar for summary disposition contained in Michigan Rules of Criminal Procedure or Chapter 6. I know that the people also state that when it comes to a preliminary examination, that is the only route or the only way in order to tackle the case, but we would say that that is not true. Dispositive motions are permitted pursuant to court rules. And in fact, we did cite a few different cases within our brief, one in particular where an indictment was dismissed by a district court. So with that being said, just as a preliminary matter, we do believe that this is something that can be raised. If I may get to the merits, Your Honor, taking a look at the timeline here, we have a few different statutes, and I'm not going to read my whole brief because I know that this Honorable Court read everything already. But first, Mr. Frost, in addition to the other 15 that were charged, they are essentially electors that were picked by the Republican Party. This is pursuant to MCL 168.42, or period 42. And then, when it came to election day, people were able to vote for presidential electors, and that's pursuant to MCL 168.45. And then, after the election was essentially canvassed by the Board of Canvassers, and they reported to the governor who won, and that was, at that time, and still is, and forever will remain, President Biden, the governor, pursuant to 168.46, filed a certificate of ascertainment, stating that when it comes to the election, that election was won by Biden, and more so when it comes to the 16 electors, who those Democratic electors would be. And that was essentially given to the Congress in addition to other appropriate individuals. We have that particular item contained as Exhibit C within our motion. But really, when we take a look at all of this here, we see one big important thing. There was absolutely no forgery in this case. None. Why? Because when it comes to forgery, forgery requires that you actually have an act that makes an instrument appear what it is not. And second, you need to actually have a risk, a real risk, to expose someone to loss. In this particular case, you don't have either. For example, if I take a look at the instrument that the individuals allegedly or purported to give to Congress and to other individuals, they didn't claim to be the Democratic electors. They signed their own names. This is a political protest, if anything. They did not state that, they had the governor's signature or the Secretary of State's signature or the Great Seal of the State of Michigan, all these other things required by the various statutes and the various laws that we cite in our brief. They just sent in a certificate, which is contained, as you have seen within the brief, as an exhibit. And there was also no potential exposure to any type of loss. I'd like to point the court's attention that this is a requirement in Re Lloyd, a Michigan Supreme Court case contained at 424 Mich. 514. It's a 1986 case. And why was there no loss? Because the governor, she wrote a certificate of ascertainment. She said to the folks in Washington, D.C., these are going to be the Democratic electors. These are going to be the individuals that will be voting. You'll be hearing from them later on December 14th. And then on December 14th, of course, we had a whole bunch of different things being submitted to Washington. The Democratic electors submitted their certificate, and when it comes to the Republican electors, they allegedly submitted their certificate. Even when it comes to that particular certificate, it's not a forgery, and there is no way that anyone could lose. Why? Because Congress is required by statute, and specifically, if we take a look at 3 U.S.C. 5 and 3 U.S.C. 6, and also 3 U.S.C. 15, all of these particular federal statutes state that it's going to be based upon the conclusiveness of what the governor has put forward, and that is that certificate of ascertainment. So no one could have been exposed to any type of loss. No one in this particular case can say that there was a dummied up certificate where it forged the governor's signature, the Secretary of State's signature, it had any type of seals, anything like this. It is legally impossible, absolutely impossible for these folks to have committed a crime with the facts being alleged. So pursuant to MCR 2.116C8, taking a look at the allegations, and in the most favorable light toward the non-movement, and that is the people here, there is no crime still. There's absolutely no crime. It precludes even the necessity for having a preliminary examination, because that brings up questions of law and fact, and a dispositive motion would be the appropriate venue, and that's why we're bringing this here, to ask for this case to be dismissed. Oh, one more thing, if I may, and that is, when it comes to the people's response, I think it's very important to note that they did not submit anything whatsoever, not one shred of argument, evidence, law, statute, anything to fight against or to contradict what we have put forward. They just said blindly that this is not something that you could do, a motion for summary disposition. That's it. They didn't even argue in the alternative. They had 20 pages they could have done all this, and they just decided not to write anything. The way that I take a look at this, and many others I would contend, is that this is really an admission that all the different things that we have stated in our motion are true. And if true, we should be prevailing here, and Mr. Frost should be set free.
Thank you, Your Honor. First and foremost, the people believe that the criminal matter before this court is properly governed by Michigan Court Rule 6.110. As it relates to Michigan Court Rule 2.116, in order for there to even be a motion of summary disposition, there has to be either a civil action where there are agreed upon stipulation of facts, or there has to be some sort of stipulation of facts sufficient enough for the court to render the judgment on the action. Point in fact, there are no facts on this record as to this case. An attorney's arguments are not facts. Filings are not facts. The proper way to elicit facts in this case is the preliminary exam, which is governed by the Michigan Court Rule 6.110, as the people stated in their response. This is a complaint, and the court's jurisdiction is set forth in 6.110, and as far as making a determination on how this case is to proceed, whether it does proceed to trial or whether the court finds that the evidence is insufficient as to probable cause, is all governed by 6.110, and it requires a preliminary exam. The people, just like the defendant, have a right to a preliminary exam, and the people have not waived their right in this case. And we believe the defendant's motion for summary disposition should be denied.
A brief response or rebuttal, if I may. Briefly, when it comes to this particular case, this is not a question of fact. Again, it's a question of law. And when we take a look at what has been put forward by the people on its face, and this is what a C8 motion is about, it is not sufficient to actually sustain the charges or what the people are looking for. There is no relief that could be granted, given that it's a legal impossibility for these folks to have possibly committed any type of crime being alleged here regarding forgery.
can have a seat.
Thank you.
I reviewed the briefs and the responses to those briefs, and also reviewed the attached legal basis for the defense argument. The concern that I have, I agree, or tend to agree with the Office of the Attorney General as it relates to when it's appropriate to apply Michigan court rules. I don't think we're in a situation here where it's appropriate to bring a motion for summary disposition. This is a criminal proceeding, it's a felony criminal proceeding. And a felony, the defense and the prosecution has a right to a preliminary examination. And the purpose of the preliminary examination is to require the prosecution to put forth sufficient evidence, that's facts, to establish if they have sufficient probable cause that a crime was committed and probable cause to charge your client with the crime. We've not done that. So to make an argument that we should do a disposition based on a summary of the proceedings would be inappropriate, and it would be preemptive. It should be something that should be, if given or taken before the court, maybe at the circuit court level, definitely not at this level, because we've not even had a preliminary examination. We don't even know if they have sufficient facts to determine whether or not a crime was committed. All we have is a pleading, and the allegation here is that there's several counts of a crime being committed. Count 1 being conspiracy to commit forgery. Count 2, forgery. Count 3, forgery. Count 4, conspiracy to commit uttering and publishing. Count 5, uttering and publishing. Count 6, conspiracy to commit forgery, election law, and then count 7 and 8, forgery, election law. We first need to have a hearing in the court, and that would be an evidentiary-based hearing for the Attorney General's office to put forth evidence and to determine, and the court will make that determination as to whether or not there's sufficient evidence to determine whether or not there was a crime that was actually committed, and if so, there's sufficient probable cause to charge Mr. Frost with that crime. And as you should be aware, that's a low burden. It's not a heavy burden to overcome. It's more than mere suspicion that a crime is committed. So for those reasons, your motion for summary disposition will be denied.
Thank you, Your Honor.
This matter will be proceeding to a preliminary examination. We also have the matter of a motion to sever.
Yes, Your Honor.
And I don't need you to obviously argue your entire motion. I do want you to, however, address the response that was provided from the Attorney General's office, where they indicate, and I would agree, that you failed to articulate any reason why there would be a requirement for a severance in this matter.
Well, if I may, Your Honor, taking a look at the court rules, specifically MCR 6.110A, it speaks about co-defendants. In this particular matter, Mr. Frost, in addition to the other 15 defendants, are just simply that. They're defendants. They're not co-defendants. They were not all charged in the same charging instrument. It appears that when it comes to the preliminary examinations that have been set up, that is for 10-12, in addition for 11-2, that is something that the various other attorneys, or more so the other defendants, have agreed to do so en masse. I would argue that when we take a look at this particular case, because Mr. Frost is not technically a co-defendant, he's not able to be joined with others in the same preliminary examination. I would say that we could certainly take a look at a court rule, and that court rule is MCR 6.121. That talks about permissive joinder, about separately charged parties, and those parties could be joined together, but that's only if we actually have a criminal information, and we're not at that point because we haven't had a bind over at this point. And furthermore, even if this court would say that they are co-defendants, which I would maintain factually that they are not, that they would certainly have antagonistic defenses and offer proof, as the prosecutor has brought up, or the Assistant Attorney General has brought up. That's not required per the court rule for 6.110A for any type of joinder or severance for preliminary examinations. In fact, that's something that's required by court rule if we're at the circuit court level. So what I'm asking here, Your Honor, is that we have a separate and distinct preliminary examination for my client, because there is not proper authority, nor was there any type of joinder here. If the Attorney General wanted everyone to be together and mandate that, that would have to be done in the same charging instrument, but they were all charged separately. And it's kind of perplexing as to why they were all charged separately. I'm not sure what the strategy or what the rationale was. Doesn't matter to me. But what does matter to me is that my client certainly has a right to a preliminary examination that be separate and distinct, and he cannot be joined with other, I'm going to call them de facto co-defendants, because there isn't a single charging instrument.
Ms. Lovey,
Thank you, Your Honor. Just to supplement my response, Michigan Court Rule 6.110A says that the preliminary examination of co-defendants shall be consolidated, and only one joint preliminary examination shall be held unless the prosecuting attorney consents to the severance, a defendant seeks severance by motion and it is granted, or that one of the defendants is unavailable and does not appear at the hearing. So what we have here today is a defendant seeking severance. As Mr. Frost noted through his attorney, the defendants were charged individually. However, by the pleadings and by the charges and the nature of the charges, all parties have essentially conceded that they are co-defendants. And we have scheduled the cases as such. Mr. Frost is not currently scheduled for a preliminary exam. However, he is charged with conspiracy, and the other 15 defendants are also charged in that same conspiracy, which, as the court and the other defendants who are not present here, and even Mr. Frost concedes, makes them de facto co-defendants. So dealing with the motion for severance in itself, we look to the authority, which is Hannah, and Hannah says that just asking for severance isn't enough, where severance would be appropriate. Where joinder would be appropriate. And there is a threshold that must be met by the defense that was not met in its pleadings.
Brief reply, if I may, Your Honor. So in this particular matter, we take a look at People v. Hannah. Well, in that particular case, you had people that actually were technically and legally co-defendants. In this particular case, we do not have that. And yes, I did state de facto because certainly that's the way that the Attorney General is taking a look at all 16 of these individuals. However, at the same time, they're not de jure or actually technically co-defendants. And because of that, I don't care what, for Mr. Frost's sake here, what the other attorneys and what the other defendants wish to do, but he wishes to have, and I believe has an absolute right to, a separate and distinct preliminary examination. My motion more so is more prophylactic than anything, and I'd just be requesting a separate preliminary examination for him. Thank you.
again, this is a matter that was charged, as indicated on the record in your argument, in a separate charging document. However, just by the nature of the facts, just as pled and alleged in the felony information sheet, it indicates to the court that this is an incident where your client, Mr. Frost, allegedly acted in concert to commit an act or a series of actions that the State Attorney General's office is charging as felonies. And it agrees, or it states that there was action or unlawful action for him to agree with several other individuals named, those people specifically named being the other defendants that were individually charged. I think it's appropriate also to remind you that the decision and discretion to both join and sever does rest with the court. We do not have a situation here where the prosecutor is granting or seeking to grant a severance. And so I would need to make a determination that there's something individual or so unique about your client's circumstances that would warrant the severance this matter from the other 15. And then that this would be in the interest of justice and judicial economy. And I don't have that reported. I don't think that this is a situation where his defense largely differs from the defenses that will be set forth from the other parties. I don't know that, but none of that has been brought forth before me today. So all I have now is not guilties of all parties and they're all being charged with a conspiracy of acting in concert to commit the same series of actions. It's not in the interest of judicial economy to separate his matter or the other 15 defendants' matters so that we can continuously have the same set of evidence brought forth before the court and have a determination made for each individual at a separate date and time. So for those reasons, the court's going to deny your request to sever Mr. Frost's matter from the other 15 cases, and he will proceed on one of the 2 dates for preliminary examination. I don't know if I already set his or if I reserved setting it because of this motion.
I believe you reserved it, Your Honor.
Okay. And so obviously there is one matter, or one set I should say, matter of these cases that is going forth next week. I don't think that that would be advantageous for you, but I'll let you advise as to whether or not you could be ready next week to go with that group. There's another set that's going to go in December. Is it November 2nd, sorry.
November 2nd, Your Honor.
And then there's at least one who has not been set, and at this point it's going to be set in either late November, December, or January.
If that's a possibility.
Correct.
And I would say.
You would ask for that. That's no problem. I will plan to set this one on that date. Give me a date. Why did that not set the
The defendant that hasn't been scheduled yet, that has a probable cause conference, is scheduled for that PCC on December 15th at 10 a.m., Your Honor.
Okay. Can you make another probable cause conference on that date, and then you can set a date and combine everybody's calendar at that time?
Thank you.
Okay, so that's what we'll do. We'll set this matter for a probable cause conference on December 15th. And albeit I deny your motion, and we're moving forward with just one other individual, so that could be some sort of a concession.
Well, we respect the court's opinion, and certainly we will abide by the court's word.
Any additional matters for the record on this file?
Nothing further, Your Honor, from Mr. Frost.
Nothing for the people, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
what they wanted to, because they can't admit that what they did violated the law because they still think they're right. In the county where Lansing is located, is a very, very democratic leaning county. But I worry that there will be people who just won't care that they clearly violated the law because they believe that the ends justify the means, and that, you know, it's okay to do as long as the end game is getting this autocrat into office, who will surely be the end of democracy in this nation.
Your Honor, we make this motion for dismissal and discharge because there can no longer possibly be a finding of probable cause. No matter what amount of evidence the people provide in preliminary exam, the people have nullified the affidavit upon which they filed this case. Two important issues were not mentioned in the people's response to our motion: specific intent and MRE 801 D2D, an admission by an agent of a party opponent. Now, the defense is not taking any position regarding the facts of this case. We're not required to. The defendant remains presumed innocent, and the burden of proving her guilt beyond a reasonable doubt remains upon the Attorney General. This issue is not about what the defendant said. This is about a genuine question regarding the accuracy of the charging affidavit that has been raised by the prosecutor. The affidavit states that the defendant knew there was no legal reason to create an alternate slate of electors on December 14th, 2020. But on September 18th, 2023, the prosecutor directly contradicted the affidavit by claiming that the defendant was brainwashed, believed that she was in the right, believed Donald Trump won the election. The Attorney General added that the defendant cannot even plead guilty because she still believes that what she did was right. Again, Your Honor, this is not our position. It is the position of the Attorney General regarding the specific intent of the defendant she is prosecuting. Convictions here would require the Attorney General to prove beyond a reasonable doubt that the defendant intended to cheat or deceive. The Attorney General cannot make that assertion now, let alone prove it beyond a reasonable doubt, because she now claims that the defendant believed what she was doing was right. This isn't the position of a layperson. This is not the position of some random attorney or an expert witness. It is the position of the prosecutor. The people claim in their response that the court has no jurisdiction to dismiss. Now, when criminal charges are filed in Michigan, a police officer often performs a swear-to in front of a judge or a magistrate. And when that happens, there's often a little back and forth. Judges and magistrates ask questions of the officer about the facts. There was no such opportunity here because an affidavit was filed instead. The court now knows that the prosecutor disagrees with paragraph 27 of the affidavit, which states that the defendant, quote, knew prior to their meeting on December 14, 2020, there was no legal reason to create an alternate slate of electors. That's important, Your Honor, because paragraph 27 of the affidavit is where the Attorney General alleged specific intent. Now, if the court were to learn during questioning and a swear-to that the facts alleged by a police officer were false, it would not be appropriate for the court to authorize felony charges and drag an innocent defendant through a preliminary exam. Are the people claiming that any prosecutor may subject any person to criminal charges and a preliminary exam based on an affidavit, even if the prosecutor asserts that the affidavit is not true? Now, the court knows that the Attorney General's position is that the defendant had no intent to cheat or to deceive. The court has an obligation to inquire about the claims made in the affidavit, acknowledge that the prosecutor claims the specific intent portion of the affidavit is false, and discharge the defendant. The people claim in their response to our motion that the Attorney General's statements are not relevant. They assert that the statements are mere opinion, and that an attorney's opinion cannot make something more or less probable. They point to a hypothetical of a prosecutor trying to admit evidence that a defense attorney thinks their client is guilty. That hypothetical ignores the fact that the defense attorney is not the one prosecuting the case and is not the one tasked with the they point to People v. Smith, in which the Court of Appeals found it had been improper, although not enough to reverse, for the prosecutor to argue that the jury should infer from the prosecutor's charging decisions that the prosecutor had knowledge that the defendant was guilty. But Smith was about protecting defendants from prosecutors unfairly wielding the prestige of their office like a weapon to unduly convince a jury of a defendant's guilt. That case says nothing about a prosecutor stating that a defendant charged with specific intent crimes did not have the necessary intent to commit those crimes. Smith was meant to ensure that the prosecutor didn't have too much power. That is simply not the case here. The people then claimed that the Attorney General's statements were opinion, a conclusion that would not assist the fact finder. These statements, Your Honor, were not mere opinion. They were an admission by the agent of a party opponent and therefore admissible under MRE 801D2D, which allows statements that are made by the party's agent or servant concerning a matter within the scope of the agency of employment and made during the existence of that relationship. The Attorney General is the agent of the people of the state of Michigan, a party to this case. Her statement absolutely concerns a matter within the scope of her employment. It was made about this case while she was prosecuting this case at an event that advertised she would be discussing this case as the Michigan Attorney General. The fact that an agent is an attorney has no bearing on whether the statements of an agent come in or not. The people then argue that witnesses cannot offer opinions of guilt. While that may be true for certain witnesses, it is not true about the parties. A defendant may allege that she is innocent, and a prosecutor may allege that the defendant is guilty. A defendant may allege that she is innocent, and as has happened here, a prosecutor may allege that a defendant is innocent. This is about a party making an admission, not about a non-party witness offering an opinion. Now, if the defendant were to have sent a text message to someone claiming that she did have the specific intent to commit these crimes, and if the prosecutor became aware of that text message, would that be admissible? Absolutely. It would be an admission by a party opponent. It would not matter if it were a conclusion of guilt or not. The Attorney General then cites cases dealing with conclusions of expert witnesses like a Michigan Gaming Control Board investigator, medical professionals, or a traffic crash reconstructionist. The statements here were not made by a state gaming investigator. They were made by the party that is prosecuting the case. The people also argue that the defendant has no right to a dismissal based on the Attorney General's statements. They claim in their response that there is no conflict between the affidavit and her September 18th statements. They inaccurately characterized the statements, saying that the Attorney General was only speaking about whether the defendants would take responsibility, and they compared the Attorney General's statements to a prosecutor casually calling a defendant crazy, saying that that would not concede that they were legally insane. But that's not what she said, Your Honor. The Attorney General claimed that the defendants legitimately believed that Donald Trump won the election and that they believed they were in the right. She didn't speculate about the probability of them taking responsibility. She said they cannot plead guilty, even if they wanted to, because they still think that they're right. The people also argue in their response that the defendant's beliefs are only minimally relevant. That's simply not true. These are not general intent crimes, like battery or drunk driving, where the prosecutor's burden is merely to prove that a person intended to commit an action that led to a criminal act. This case involves allegations of specific intent crimes: conspiracy, forgery, uttering and publishing, and election law forgery. All of these charges require proof beyond a reasonable doubt that the defendant acted with the intention of cheating or deceiving. The defendant's belief regarding whether she is cheating or deceiving anyone is more than just relevant. It's an element of each of the crimes. We now know that the prosecutor's position is that the defendant herself did not believe what she was doing was wrong, because according to the Attorney General, the defendant was the one who was deceived. The people also argue that these statements come from a short video clip that lacked nuance, that it did not fully encompass the Attorney General's position on the matter. I cannot possibly think of any conceivable context that would unring the bell, and the people presented none in their response. If the court does still have questions about the prosecutor's position on the issue of the defendant's specific intent, we believe an evidentiary hearing herself claims that the defendant did not commit the crimes. The people should not have the right to subject a person to an exam simply because they filed an affidavit with the court. Here, a genuine question has been raised about the accuracy of the affidavit. And yes, a preliminary examination would ordinarily be the proper venue to investigate such a question, if the question was raised by the defendant. But here, the genuine question about the accuracy of the affidavit has been raised by the prosecutor who filed the affidavit with this court to commence this litigation. We are respectfully requesting that the court dismiss the charges against Ms. Henry. In the alternative, we're asking that the court fulfill its obligation to investigate the genuine question of the affidavit's accuracy, a question that was raised by the prosecutor.
Thank you, Your Honor. First and foremost, I think there is a clear disagreement about what the Attorney General said in her statements. Whereas the defendant believes that these statements are directly commenting on an element, the people contend that those statements comment on whether or not a defendant can plead guilty and admit guilt, which is not an element in any of the 8 counts before this court. And as far as a defendant's genuine belief that what they are doing is right, even if they're doing something wrong for the perceived right reasons, still makes that act wrong. And as noted in the people's brief, there is no evidence right now before this court about the sufficiency of mens rea for this defendant or any of the defendants, because we have not had our preliminary exam yet. And when the people make allegations, whether it's in an affidavit, whether it's at the exam, whether it's at trial, those allegations are not evidence. The evidence comes from witness testimony. It comes from the presentation of documents, which again has not happened in this case. So extrajudicial statements made by the Attorney General are not evidence that can be put before this court right now. It is the people's belief that it can't be put before the court, period, based on the case law that we cited with Farland at 325 Mr. Pill 507, the 2018 case, People v. Fomby at 300 Mr. Pill 46, the 2013 case, which says experts and the top law enforcement officer could clearly be defined as an expert, cannot give an opinion of the guilt or the guilty state of mind of a defendant. This would never be admissible in court. And first and foremost, as the people said in our response, the court has limited jurisdiction when it comes to a felony complaint. And when it comes to a motion for dismissal, it is properly heard after a presentation of evidence, which we refer to, multiple times, a preliminary examination. We have one scheduled in this matter. It is the people's position that at that point, the defense can properly argue that the evidence is insufficient and not before. The Attorney General's statements do not create a right to dismissal before the court can hear the evidence, which the court has not heard. Thank you, Will.
Simply clarification, Your Honor, as far as what specific intent crimes are. They do differ from general intent crimes. This is not about the outcome being wrong. For specific intent crimes, the intent must be wrong.
So we've heard both the argument as well as the responsive argument from the Office of the Attorney General. You've also played a video. I'm still trying to
statement made by the prosecutor. There's no disagreement about the accuracy of it having happened. It did happen last month.
Okay, she made a statement that there was a concern about whether or not the defendants had been brainwashed.
Your Honor, I would disagree with that characterization. She didn't say that there was a concern. She said that they had been brainwashed. She said that they believed that they were right. They believed that Donald Trump won, and that because of this belief, because they still believe